Greetings and welcome to the DC Bar Pro Bono Center's Nonprofit and Small Business Programs podcast series. On a monthly basis, we talk to experts on legal topics of note to nonprofit organizations and entrepreneurs. I'm Darryl Maxwell, Assistant Director for the Pro Bono Center's Nonprofit and Small Business Legal Assistance Programs. Today, we're going to focus our attention on for-profit businesses. We'll be discussing government contracting, collaboration for small businesses. I am pleased to welcome my friend and colleague, Ken Brody, to help us with this. Ken is a named partner in the firm David, Brody, and Dondershine, LLP, located in Reston, Virginia. He has over 40 years of experience in government contracts law, commercial litigation, and employment law. He's a graduate of Georgetown Law, the Georgetown Law Center, and is licensed to practice in Virginia, Maryland, most importantly, the District of Columbia, as well as New York. Ken's practice includes advising large and small companies on all aspects of procurement law, including issues related to prime contract and subcontract awards, performance, and termination. He is also a frequent lecturer at training events for government contracting personnel, for PTAC, PTAC, and other groups, and has written extensively on topics in the procurement field. Ken, welcome.
Thank you very much, Darryl. Great to be here.
Great. And I will also add the note that Ken is one of our Pro Bono Center's favorite volunteers who has been a faithful volunteer for a number of years with the Pro Bono Center at our monthly clinics. One of the things that we have a tendency to see at our clinics and entrepreneurs have questions about are government contracting. They sort of have this sort of mythical idea of what government contracting is or where they might be able to provide some sort of service, either here in this area, you've got both the federal government and local governments. On a sort of relatively high level, for our listeners, we want to get a sense for what are maybe the best strategies particularly for newer businesses, but also for really small businesses who want to get involved in government contracting. What are the things they should be thinking about?
Well, small businesses, particularly very small businesses, should probably be thinking about identifying another company they can work with. They're not going to be able to do this on their own at the outset, and it's best to find a good teaming partner if you can, or teaming partners, and develop relationships with these companies. They can show you how to get into the field. They can teach you about the process and procedures, and they can also help you in some cases grow your company. So I would suggest that small businesses that are looking to get into this field start thinking about how can I identify teammates? How can I identify large companies? Where do I find them? And what do I have to offer to them in order to make me an attractive teammate for them on one of their projects with the government?
So let's say, for example, Ken, you've got a supplier of, I'm going to say, toilet paper, paper towels. Really small company, they think maybe they want to work with the GSA or some other large federal agency. What's the best sort of move for them to find sort of somebody bigger and make themselves more attractive to possibly work with this bigger company in order to sort of work on maybe finding that government contract?
Well, it's not easy. It's certainly not an easy thing to start a business, particularly a business in the government contracting field. But what I've seen are companies that really are serious about getting into this. They will heavily network. They will understand what it is that they sell and where the customers are. Perhaps if it's GSA, if that's what they're selling, or if they're selling some other technical service that might be attractive to a particular agency, to try to focus on who in the government would be interested in what you're selling, and identifying who the purchasers are. In the course of doing that, you will also get to learn who the other large businesses are who are doing this work for those customers. So basically, it involves market research. It involves learning who the government customer is. And when I say the customer, I mean the government agency.
Sure.
But it also involves then identifying who are the other large companies that are selling these services to those agencies, and where can I fit in as part of their team.
It's a really good point. And one of the things that I just wonder, for the crazy guy who thinks, I think I can do this on my own. Do you have any sort of, from your experience, are there folks who have sort of walked into this area and actually been able to be successful on their own without the help of a larger company? And how rare or not rare is that?
I would say from my experience, it's pretty rare, but I don't think it's necessarily impossible. It may also depend on exactly what it is you're offering. I mean, if you've got a skill, a very specialized skill, if you have a unique service you offer or unique product you offer, it's possible that you might be able to develop direct relationships with government agencies with respect to those services. So if you're offering something very specialized, that's something to consider. But even in that situation, I think generally speaking, it's smart to develop teaming relationships, especially if you're not familiar with the turf. I mean, just to get a general overview of what we're really talking about. Teaming involves identifying another company that you can work with to compete for government contracts or to get government contracts, and figuring out how to establish a relationship with them that furthers your ability to go after the work. In the first instance, because you have to win the work before you can get the work and get paid. So the first step is to figure out who you can team with and what will that entail. How do you develop a teaming relationship? How will you allocate resources between the companies to prepare proposals? And how will the companies divide the pie if they win? Those are issues you should be thinking about exploring with a potential teammate to initially establish a teaming relationship. And if the team is successful in winning the work, and if they do agree to divide the pie as they hopefully worked out as they entered into this teaming relationship, they can then proceed to establish a more formal subcontracting relationship to describe how they're going to actually do the work. So basically, we're talking about relationship building. We're talking about establishing perhaps contractual relationships with companies that define how they're going to go after work through a teaming agreement and how they're going to actually perform the work if the team is successful.
So to that point about teaming agreements, I'm the business owner that's new to this area, but have done my sort of networking, I've done my own marketing of my own company, and I've found a company that I believe will be a good teammate, as you mentioned. How do I protect myself in the context of this agreement, particularly if we're thinking, you're working with a much bigger company, and you think, well, maybe they've got a ton of leverage. How, as a smaller business, again, as many of our listeners are going to be smaller, what do you do, or what sort of things should business owners be thinking about to make sure they're protected in one of these teaming agreements so they can actually go get some of this contract and some of this money out there?
Well, that's a really good question. It's one of the more difficult aspects of establishing teaming relationships. Small businesses, particularly brand new businesses, might feel intimidated working with a large company. And might be desperate in some cases even, but we generally try to encourage small businesses to establish written teaming agreements with companies, which outline how the company is going to work together to prepare proposals, and more importantly, how they're going to allocate the work if the team is successful. One of the goals a small business should have, if possible, is to get their larger teammate to agree in writing to their piece of the work, their percentage of the hours perhaps that will be involved in performing the work, or their portion of the technical part of the specifications that are under consideration. In other words, you should strive as a small business, if possible, to get your teammate to clearly articulate what you're going to receive. And sometimes it's hard to get companies to agree to these things. I generally advise small businesses not to be afraid to push back on these questions. If they're getting, for example, into a situation where a large company says, we want you to help us win this procurement, but we can't tell you exactly what we're going to give you if the team is successful, that should be a red flag. generally. Sometimes it isn't always easy to define exactly how the work will be split, but you should be thinking about that and not afraid to raise those issues at the early stage of establishing the teaming relationship. That will probably be helpful later on. We generally find that companies that are able to get their teaming partners to at least put in writing some sort of specific allocation of work will probably fare better in the long run.
And as a follow-up to that, would you say in your experience most business owners, both small and larger, in teaming agreements, and because of your background and some of your background in litigation, do folks have a tendency to stick to those and honor those teaming agreements? And I'm just thinking of the percentage of work that's sort of explained in the teaming agreement versus the practice of performing that work to compete for the contract.
Well, for better or for worse, there's a lot of debate over this issue. The truth is, it is a challenge to enforce teaming agreements. There have been numerous cases where teaming agreements have not been enforced by courts. It's not litigated that often because it involves typically small businesses who are not inclined to engage in litigation. Mm-hmm. So the point is, it can be difficult to enforce teaming agreements, but we generally feel that if you make the effort to get some sort of specific allocation written into your teaming agreement, odds are you're going to have a better shot at getting what you expected than when you are entering into a teaming agreement that has kind of a wishy-washy allocation of work provision, which from a legal standpoint is very difficult to enforce.
Right. Okay. And I know we had talked about this a little bit before, but if you have any instances of cases where the folks who were a part of a teaming agreement were able, or at least maybe the larger company in the teaming agreement was able to sort of take a mentorship role with the smaller company involved to maybe sort of help bring them along and sort of gain some experience. I just wanted to see if you could shed some light on that as well.
Well, teammates often expand their relationship. They get experience working together. They might get comfortable with each other, and at some point, a small business should consider mentoring with a large business under the SBA's All Small Business Mentor Protege program, which is a relatively new program, which actually opens up some additional opportunities for marketing and getting business. Basically, the Mentor Protege program under the SBA's regulations allow large businesses and small business proteges to create formal written binding mentor protege agreements, which outline what the mentor can do to help the protege, namely what kind of contracting assistance can they provide, what kind of infrastructure assistance can they provide, what kind of financial assistance might they be able to provide to the protege to help the protege develop. And this is great, of course, for a small business if they can find a mentor who's willing to do that, someone they can trust. Sure. And through this program, the mentor gets something out of it too, of course. They don't do it as a charity. Under the SBA regulations, mentors are allowed to establish what we call joint ventures with their proteges, which are sort of like teaming agreements, except they're really kind of a special type of teaming arrangement where the mentor and their protege form a new entity called a joint venture, and that new entity can go after government business. Mm-hmm. And they can specifically go after set-asides for small businesses and small disadvantaged businesses and be considered to be the size of the protege, even though they are a joint venture of a large business and a small business. So what that basically does for a large business is it gives them more access to small business set-asides, frankly. And that's what the appeal is. They get something, the protege gets something out of this relationship because now they are getting the benefits that are outlined in their mentor-protege agreement.
And another thing I want to make sure to emphasize, because of your expertise and because of these types of relationships, whether it be a mentor-protege or a larger versus smaller company, but I'll particularly go to the mentor-protege sort of arrangement. How does the protege sort of work to sort of make sure, and I know this is probably difficult, but how do you work to make sure that you're a protege, or in the joint venture agreement that you're a member or you're a partner in the joint venture, versus it being more of sort of a predatory relationship?
Right. Well, that's a very important question and a very important issue. I mean, the first thing you want to do as a protege is not just jump into any mentor-protege relationship.
Thank you for that. That's
and there's a temptation to do that because it can be very appealing to a small business that's just starting out. Perhaps some large company is coming along and offering them what appears to be a nice deal, but they could do better perhaps. Generally, it's smarter to develop your business a little bit before you go into the mentor-protege program. Get some experience under your belt, learn the terrain a little bit, and develop relationships with prospective mentors before you take the plunge and go into a formal mentor-protege relationship. Under the SBA rules, you only get a shot at having 2 mentors over your entire lifetime. So you want to make the choices correctly. And you don't want to waste one of your mentor-protege opportunities. You want to probably then consider a mentor after you have developed a working relationship with them under teaming and subcontracting agreements and have decided this is a company I can work with. Of course, the mentor is going to be doing the same thing. Mentors are going to be looking for proteges they can trust if they're a good mentor.
Right.
And so it's important to establish a positive relationship with these companies. You don't want a predatory relationship. A predatory relationship really means that it's sort of a, shall we say, a phony mentor-protege relationship where essentially the mentor is simply using the protege as a vehicle for gaining access to set-aside procurements, but is not really doing enough to help the protege develop and expand its business. The goal of the mentor-protege program ultimately is to have proteges grow into larger, more successful companies. And so your relationship should be one that will enable that to happen.
Right. And I will say at our small business clinics, over the years, we've had a number of business owners who have entered, I think, unwisely into agreements where either there was a collaboration with a larger company where the expectation was they will use, and on the district government level, that program is called the Certified Business Enterprise, and there would be a need for some percentage of the work in this joint agreement. I would say typically it'd be 15 to 20% done by the smaller company, and even though that was evidenced in an agreement, typically the larger company was doing most of the work, or way more than that percentage, that the 75 or 85%, and not cutting in the smaller company into sort of all the trappings of this agreement. And so trying to make sure, and one of the things we're always trying to counsel clients on, is trying to make sure that that there's a mechanism for you to be able to try to enforce the provisions that are in the agreement, and B, that the agreement is worth your while and that it makes sense to you before you've signed it. And I think it's really great advice to share that folks should be thinking about these things before they sign, because we get a lot of folks who come in and they've already signed it and they don't know what to do next.
Right. Yeah, one of the mistakes that a lot of companies have made in the past, and I think SBA has been trying to clean this up, is they've been giving away equity in their small business to their mentors. The mentor-protege program, at least the SBA mentor-protege program, allows mentors to purchase up to 40% of the equity in their protege. Now, while they're permitted to do that, because that's considered financial assistance, that is not necessarily a smart thing to do from the protege's point of view, especially when you're first starting out. So I I would generally counsel companies to steer away from mentors who are interested in buying their company from them before they really got going. There have been mentors in the past that have been known to speculate in these companies, and that's what they're doing. So generally, be leery of a mentor who is interested in taking an ownership in your company. After all, the point here is to grow your company, to make it more valuable. Don't give it away before you've had a chance to grow it.
Right. And I want to make sure we get to subcontracts and implementing and finally getting the contract. And then, Ken, if you could talk a little bit about how do we implement this wonderful thing that's happened, and also sort of how do we protect, we're talking about small businesses, how do the entities protect themselves in sort of the performance of the subcontract?
Well, there are a number of issues to be particularly concerned about. And as I mentioned earlier, don't be afraid if you're a subcontractor of pushing back on some of the terms and conditions that might be getting presented to you in the subcontract. Typically what happens is the large business will present the subcontract to their subcontractor, small business partner. This is all assuming the team is successful in getting the work, which is a good thing. Now you're going to negotiate a subcontract that will identify how you're going to work together in the terms and conditions governing the performance of the work. And in terms of protecting yourself, you want to identify at least a few things that are always issues when negotiating these agreements. For example, how easy is it to terminate the subcontract? If you're a subcontractor, you want to be careful about signing a subcontract agreement that allows the prime contractor to terminate the subcontract more or less at will, especially if you played a significant role in helping them win the prime contract. You've done all this work under the teaming relationship to help the prime contractor win, and now they want you to sign on to an agreement that basically says they can terminate the relationship prematurely. So you want an arrangement that basically requires that you be allowed to participate in the performance of the work for as long as the prime contractor has a prime contract. That's essentially one, and that's one very important point that I would emphasize, and I would push back on issues in terms and subcontracts that do not accomplish that objective, if possible. You don't always get it, but I think that's something that is very important. Another issue that I think is also very important is to make sure there are no restrictive covenants in the subcontract that might unfairly restrain your ability to develop your business. For example, don't sign on to non-compete provisions that preclude you from competing in the future against your prime contractor partner. One of the interesting things about government contracting and teaming is you're kind of teaming and subcontracting with past or future competitors.
Right.
So in that context, you have to protect yourself in ways that do not undermine your future competitiveness. Along those lines, you also want to consider putting provisions into your subcontract that would preclude your teammate from poaching your employees. If you have employees and you're a service contractor, for example, and you've gone to a lot of trouble to build your company and to hire people who can do the work for you, now you're introducing them to your teammate under your teaming relationship and your subcontract with your prime contractor. You don't want them to take that as an opportunity to hire them away from you and make you kind of irrelevant in the relationship by doing so. Right. So you need non-solicitation of employee provisions in your agreements typically.
Those are non-compete is definitely something that we see a lot. And then also sort of if there are any sort of issues where there's sort of a distance by where like or not being able to compete within a certain area. That's another thing that we see a lot where folks who might have gotten into an agreement and say, I'm good, but I'm going to operate in Virginia and maybe you can operate in the district, which sort of certainly can wildly limit sort of what your actual opportunities are to grow. And if you're supposed to be, if you're subcontracting, and the whole point of this is to try to grow your practice and grow your business, that can be really a challenge.
Yeah, I mean, non-compete or non-solicitation provisions can be tricky. At a minimum, they should be topics of of negotiation if they are presented to you. Another very important issue to consider also is to making sure you have a sound payment provision in your subcontract. To make sure you're going to get paid,
Right.
and get paid relatively promptly. It's preferable for very small businesses to try to negotiate agreements that clearly state that they will be paid within a net number of days of invoicing, as opposed to provisions which might require them to wait until the prime contractor is paid by the customer. Prime contractors might ask small businesses to agree to such provisions. Many do not. Many are willing to pay their subcontractors without making payment contingent on their getting paid by the government. But if you're a very small business, you can't afford to have to wait to get paid. And most large businesses are probably going to be willing to agree to a provision that calls for them to pay you within a set number of days, and thereby create some certainty as to when you're going to get paid.
Sure. And I know there are always issues both in the district level, it's been my expertise, and on the federal level with the customer not paying on time. And this is a really helpful way for where your prime contractor is going to be a huge help to your smaller business if they can make sure they can pay the folks that are working for them on time versus having to be stuck sort of waiting on the government, in which case you could be waiting 3 months, 6 months. I think I've seen as long as 9 months for government contracts to be paid off or to even start being paid. So Ken makes a really good point. I think that's a really something that needs to be noted when you're putting this together. I wanted to ask sort of if you had any either client, whether success stories, pitfalls maybe that you wanted to share as we are about to wrap up. Just wanted to get a sense because of your expertise, like if you had any cool, interesting stories, or maybe even sort of a danger story, just to sort of to focus our listeners.
Well, as far as danger stories are concerned, I mean, we get a lot of danger stories in our line of work. I can say without getting into specifics that we have had clients that have, I would say, too quickly agreed to non-compete provisions that were problems later on. I think there's a temptation to ignore those types of provisions. There's a temptation to ignore a lot of things in these subcontracts. And the truth is, the best subcontract is the one that you never have to read. And if it's well prepared and well drafted, and the parties have a good relationship, they'll probably never need to actually read the agreement. But if the agreements are not well prepared, they can change the dynamics of the relationship. And that's what we've seen happen with some clients in some of these cases, for example, where they have agreed to non-compete provisions that they probably didn't expect were going to ever come back and be an issue, but were. And we've had several cases involving primes and subs litigating over restrictive covenants because those issues were not addressed earlier during the negotiations of the subcontract. So I would just warn folks that it makes sense to at least take the time and make the effort to understand what you're signing before you sign it,
right.
And it probably pays off in the long run.
Okay. Any positives? Any success stories that you might have?
Well, in terms of success stories, I mean, we have been able to work with a number of small businesses who, for example, who have successfully developed subcontract relationships with other companies that appear to be working very, very well. Even though the negotiations for their subcontracts could be trying at times, I think working with a company, and we've had a number of clients who have had negotiations with large companies. I think good companies kind of respect other companies that raise legitimate issues and are willing to work with them. And we've had that kind of experience with a number of our clients who have negotiated subcontracts, which have worked out pretty successfully for them.
Ken, I just wanted to say thank you so much for all of your insights. For more of these insights, you can always join Ken at one of our monthly small business clinics. You can also join him at procurement technical assistance centers. I know there's some in Virginia that you frequent, and we will certainly share that information as well once the podcast is up. For more information or access to our other podcasts, which we actually do talk about non-competes and other things that we've talked about, as well as government contracting today, webinars, and other helpful information, please visit us at www.lawhelp.org/DC/CED. Feel free to follow us on Twitter. My Twitter handle, Darryl, Darryl J. Maxwell. Also the DC Bar Pro Bono Center, at DC Bar Pro Bono. Thank you. Have a wonderful day.